Welcome to our second lecture covering the topic of age discrimination. During our first lecture, we discussed a kind of a general introduction to age discrimination law, and then we compared and contrasted the Age Discrimination Employment Act, which is our age discrimination statute, which we will often refer to as ADEA. We compared that to other discrimination statutes, most prominently Title VII. We also discussed the mechanism that we have in the law for filing complaints of age discrimination, the EEOC process, and how that's similar to and also different from the Title VII process. Finally, we discussed the Prima Facie framework, and again, how it's similar to the Title VII Prima Facie framework and how, though, it's different in important ways. For today, or for the second lecture, we're going to be covering the topic of RIFS, which is a term that is used for reductions in force. We'll discuss the topic of retirement, and we'll also discuss a statute that's called the Older Workers Benefit Protection Act, and which specifically addresses waivers of ADEA, Age Discrimination Employment Act claims. We'll talk about the topic of age harassment and retaliation under ADEA. We'll discuss the topic of remedies, and we'll talk briefly about ERISA. We'll talk more about ERISA in another chapter, but we'll touch on it a little bit in this chapter as well. So let's begin. I'm going to go forward several slides to material that we haven't already covered in a previous lecture. And here we go. So we're going to talk about RIFs. So what is a RIF? What is a reduction in force? Well, it is when a business has reasons for reducing its workforce that doesn't have to do with the performance, or at least not directly with the performance of the particular workers. It's because of some other kind of business consideration. It may be that times are tough and the business is not prospering. It could be that there's some kind of organizational change and this new plan is going to be more efficient. It's unfortunate, but it's true that in many cases when a reduction of force happens, good workers, loyal workers, long-term workers are dismissed or demoted really through no fault of their own. So a RIF, or reduction of force, is not about punishing people or necessarily even picking the most keeping the best workers, although certainly the way that a reduction of force is organized, employers are wise to think through how can we retain we can't keep everyone, but how can we retain as many people as possible? Now, I will tell you, though, that employers have tough choices to make in this situation. If you work either as an HR paralegal or attorney, or you work as an HR professional, you'll have to be in the trenches going through these issues. Let's imagine, for example, that you happen to work in a large retailer, and the retailer has several different locations. One particular location is losing money, and so the decision is to close that particular location. Let's assume that this retailer has 2 other locations in that market and, say, 20 other locations in another market. Well, the employer has a couple of choices to make. One thing that the employer can do is just to terminate everyone who is in the unsuccessful unit. And the good workers will go away and the bad workers will go away. Generally speaking, that's likely to be very legal. It is, in some sense, a very safe strategy from a business perspective. But it's also likely that the employer is going to lose some good workers that could have made meaningful contributions to the organization. So what the employer might do, even though it's a little bit more legally risky, is the employer might allow or might consider people in all 3 of the units in that particular geographic category. Let's say that there is the need for only 1 store manager. Well, instead of automatically dismissing the store manager in the closing facility, you might compare the 3 store managers in those 3 local units and decide which one of those 3 is performing at the highest level. Now, under those circumstances, the more that you use objective qualifications such as sales or cost management or whatever the criteria that your organization put special emphasis upon, then that is the person who ought to be reduced in force. Very likely it'll be the store manager in the unit that you're closing, but perhaps you aren't closing it because it's less profitable. Perhaps you're closing it because you've lost your lease on that particular location. Anyway, so that can be one way of doing it. Now, inherently, when you RIF somebody who isn't in the closing facility, that person may think, well, why am I losing my job? My facility is still open. And so it does create a greater opportunity to see some litigation in that situation. But of course, the upside is that you are hopefully retaining a better worker than if you had simply automatically dismissed everyone who is in the closing unit. You can even extend farther than just the 3 stores or units in that particular geographic area. You could extend it to the 20 other units. One challenge with this, of course, is that there's going to be relocation costs, business disruption when people are moving here and there, and so that can present some additional points of confusion. There may be different processes and procedures in the other locations, and so there could be some learning curve associated with that change. What I'm trying to communicate more than anything else is that there is no perfect RIF process or perfect RIF solution to these problems. They involve the culture of the organization. They involve considering the degree of legal risk that is presented in a particular reduction of force and the business objectives that this business might have. So there's lots of things to think about. Ultimately, it's going to most likely be the business people's decision, but you as the HR person or as the legal professional need to be able to quantify and present the various risks, both the HR business risks as well as the legal risks. So what do we need to think about from a legal standpoint when we're talking about reductions in force? Well, the rule is that however you choose to select people for the downsizing, it can't be discriminatory. It can't tend to favor men over women or women over the men for that matter. It can't tend to favor Caucasians over African Americans or African Americans over Caucasians. It can't prefer any group over another. And of course that applies to age. It can't prefer younger people over older people. Now, it could prefer older people over younger people. That would not be legally prohibited. Sometimes there's an issue in a reduction in force as to whether it really was a reduction in force or whether a particular dismissal was part of a larger reduction in force. If a person is RIFed and he or she is replaced by somebody after the dust settles, I mean, if it's part of the actual action, that's still a reduction in force. So going back to my example in which we had one unit closing, 2 remaining in effect, Unit C is closing, but Unit A store manager is being RIFed so that Unit C store manager can become the store manager at Unit A. Then Unit A store manager is clearly the victim of a RIF. And I say victim, I don't mean that to mean that any law was violated, but just that he or she lost the position. So in that situation, he or she is replaced as part of that overall reduction in force. If at some, but let's imagine another scenario. Let's say that the employer is attempting to call something a RIF when in fact it's not a RIF. The employer wants to get rid of store manager A. No unit is closing, so they kind of pretend there's a reduction in force. Oh, but almost no one is RIFed. Just a handful of people who the employer wanted to get rid of, really for other reasons. And then 6 months later, those positions are refilled. Well, that's a pretend RIF. That's not a genuine RIF. And certainly that would raise some concerns. It would seem to be dissembling So employers need to be careful about that. Many times in these situations, line managers may not be completely candid with the legal department or with the HR department about plans. And so there has to be the awareness and the consciousness that when, oh, well, we decided we do need a position there. Well, okay, but you told us 6 months ago you didn't. So is that a real RIF or is this not a real RIF? You have to ask tough questions under those circumstances. Now, in a genuine RIF, obviously the work usually doesn't go away. I mean, I guess it does go away if you close the facility, but many times you may just be taking an existing facility and instead of having 30 people work there, now you're going to have 25 people working there. Well, the 5 people that you're letting go, their work usually doesn't go away. So the remaining 25 are going to have to pick up the slack to some extent. The work in many cases is redistributed. That's usual in a reduction in force. Okay, so let's consider this particular scenario. In a reduction in force, age discrimination may be proven where an employer refuses to allow the discharged or demoted employee to bump others with less seniority. Let's pause here. In a union facility or in a facility that is concerned about the possibility of union organizing efforts, or in a facility that has a lot of workers who I don't mean to be insulting, but are fairly fungible. Lots of people do the same job in the same way, like an assembly line or something like that. In those types of environments, it's not that unusual to have some kind of bumping procedure when there's a reduction in force. Those have become less common in the last generation or so. And certainly when you're dealing with management, it's less likely that we'll see that kind of bumping process. The bumping process has some advantages, but it also has some disadvantages. When you bump somebody, many times, or if you just let someone go, they're not happy with you, but they're not there anymore. And so their dissatisfaction isn't really something that you have to wake up and face every day. But when you allow a person to bump within an organization, then you have, of course, the person that they bump out of the job, that person goes away, so you're not having to deal with that person. But now you have somebody who is now in a lower position, oftentimes a position of less pay. And that's a hard situation for that person to deal with. And so you have perhaps I don't mean buy literally, but you've entered into a situation of your own choosing where there's likely to be some hard feelings. You might think, well, they're happier having some job than no job at all. I mean, that's probably true. But if they have no job at all, that's not something that the employer has to be concerned about. Another thing that can be problematic is that it can be disruptive of the workforce. Suddenly lots of people doing new jobs that they haven't done before is going to inherently result in less productivity. But there can be some advantages. For one thing, if you have that set up, say in a union organizing or a collective bargaining agreement, you may be required to do so. And you can see why employees might like the idea of having some kind of bumping procedure, especially the longer service employees, because of course they would prefer to be able to bump instead of to be out of work. They certainly see it from a different perspective than the employer does. And certainly employers who aren't unionized may think that having a procedure that their workforce knows about where they will allow bumping may insulate that employer from union organizing efforts and may make the morale happier in the facility just generally before the RIF happens. So there can be some reasons to have it, but it's probably less common than otherwise. And it works best when jobs are fairly interchangeable. Let's look at the other requirement that would be necessary, or at least for this scenario to play out, where age discrimination is going to be pretty suggested. And that is when the employer hires younger workers at the prior salary of the older worker who was RIF'd, when the jobs become available after the older worker was discharged or demoted. This is really the important one here. The employer is not going to be able to say that, oh, well, the older worker was earning too much money, because we're hiring the younger workers at the prior salary. and the older worker didn't have the opportunity to stay employed by doing some kind of bumping procedure. So this is likely to set up at least the prima facie case standard for an age discrimination RIF case. This is a good summary of the kind of prima facie case. The one thing I would point to is that this doesn't emphasize the RFOA, the reasonable factors other than age, as much as I probably would if I were talking about this. It sounds more Title VII-ish, and it seems to be implying a burden shifting thing. So I like this section up here a lot. I feel like this section is maybe a little bit, these final two sentences, a little bit imprecise. So let's move on to the topic of retirement, where we're going to talk about mandatory retirement situations and voluntary incentives. We've already kind of talked about mandatory retirement. Generally speaking, you just can't do it. There's just a few exceptions, and these are a result of the amendments in 1986. Again, you don't need to know the year that the amendments were made, but yeah, I think it's good to know that it wasn't always this way. It used to be initially under the ADEA that you were allowed to have more mandatory retirement age scenarios. But again, as part of the changes in these laws that have happened, we're no longer in that position. So we have relatively few exceptions to the rule that says you can't have mandatory retirement. One, of course, is that first responders, those people handling crisis situations. We don't necessarily want the 75-year-old to be the police officer who is called to handle that very tense and a dangerous circumstance. So here we have Bob. He's a police officer. He's told he needs to retire at 65. He's going to get a pension of $40,000. He feels that he's good at his job. He hasn't slowed down so much that he can't do a good job, so he files a claim under ADEA. Unfortunately for Bob, because of the nature of his work, he's likely to lose because police officers are subject to mandatory retirement age, just as firefighters would. That's one of the reasons, by the way, that police officers and firefighters typically are subject or able to participate in fairly generous retirement plans. High-level, the other category, high-level employees with substantial executive authority can be subject to compulsory retirement age at age 65. There's really two elements to this exception. One is that they have to be really in a pretty significant policy-making role. The requirement here is that, you know, we want this person to be in a position where they are really kind of at the nerve center of the organization. And so it's really necessary to do some succession planning here. Well, if you can't make people retire, you can't be certain when they are going to retire, it's really difficult to do succession planning. You know, lower level managers, it's not nearly as important to do succession planning. So that's what we're focusing on when we're talking about the substantial executive authority. Then the second part is we want them to, if we're forcing them out at 65, we want to make sure that they're taken care of financially. We want to make sure that they aren't going to be unable to support themselves. And so that's where the $44,000 comes into play. If you're going to be forced out at 65, then the employer ought to be providing some generous benefits. It's not an either or, though. Both of these qualifications have to be satisfied. So let's consider a couple of scenarios. Mary's a senior VP, so it sounds like she's a major policymaker. She certainly has a major salary, so that looks pretty in line. She's notified that she'll have to retire when she's 65, and she's going to get an $86,000 annual pension. Not too bad. Unfortunately for Mary, she isn't going to be able to file a successful ADEA complaint because, again, she has a substantial executive authority and she has a pension above $44,000. Obviously, an employer cannot base employment decisions upon age-related stereotypes. So, of course, if we're looking at a mandatory retirement age under any scenario, we can't be using those age-related stereotypes to support that. Let's look at another scenario that fits in that category. This time Mary's a mid-level manager, so she's no longer the senior VP. When she turns 60, her employer forces her to take mandatory retirement in exchange for an annual pension of $40,000. You can see a couple of problems. She doesn't have that substantial executive authority. She's being forced out at 60, not 65. And she doesn't have a $44,000 pension. She only has a $40,000 pension. So really, if any one of those were not in compliance, she could still file her ADEA claim. So now she has 3 bases for it. She files a claim, and it seems likely that she'll be able to win because those 3 things have not been complied with in her situation. Okay, so let's talk a little bit about the Older Workers Benefit Protection Act, which is the OWBPA. This is an amendment to the ADEA. Keep in mind that ADEA is a separate statute from Title VII, and so the Older Workers Benefit Protection Act did not amend Title VII. That's really, really important, and it's a common error that people make when they talk about this. We'll see how that plays out in a couple of minutes. So, under the Older Workers Benefit Protection Act, it is legal for employers to offer early retirement incentives even though the minimum age or service requirements might exclude younger employees. Remember, we talked about that in that General Dynamics situation where people over 50 were given nicer benefits than people between 40 and 50. Again, the Supreme Court said that's fine. Well, the Older Workers Benefit Protection Act also says that's fine. Now, of course, it can't be the opposite. You can't give younger people benefits that you're not giving old people. And you can see how this could play out. You might have an employer say, well, you know what? We don't really want to extend this benefit package to people in their 60s because we think they're going to retire pretty soon anyway. But we really want to get rid of some people because we're just top heavy or whatever. So we want to offer packages to people in their 50s and just end it at 59. Well, that would violate the Older Workers Benefit Protection Act. You cannot deny it to the older workers just because you think they're more likely to retire. Another thing that's important to keep in mind is that when an organization is seriously considering some kind of voluntary early retirement incentive, they have to tell workers who offer their retirement. Imagine that the plan in an organization is to communicate an early retirement incentive, say, December 1st. Well, one of the candidates who otherwise would have been eligible for the package, let's say he's a 57-year-old person, submits his letter of retirement on November 30th, the day before the announcement. Well, obviously, most likely, he would have waited. If he had known that they were about to offer a more generous retirement benefits, if he waits just a little bit longer, he probably would have waited just a little bit longer. So when those plans are being seriously considered, the employer needs to tell employees, or at least give them the opportunity to reconsider their decision if the employee happens to choose to retire while it's being considered but before it's communicated. This case is a little bit confusing, so I'm not even going to go over the facts. I'm just going to get to the bottom line here. In this particular case, it's dealt with a combination of issues. Somebody in a kind of a dangerous, hazardous field who is injured or disabled, oftentimes because of something relating to the field. Well, what Kentucky allowed the workers to do is folks that had not yet reached retirement age, if they became disabled, were kind of promoted to retirement age. Because after all, being disabled, they weren't going to be able to do their hazardous job anymore, and so they needed to retire. And so Kentucky was kind of helping those people get to that magic age. In this particular case, though, the individual who became disabled was already at retirement age. He didn't need a leg up to get to that. And his point was, well, gosh, I'm 61. I'm not getting any extra goodies because I'm disabled. But if I had become disabled, say, at 50, I would have. So that means that my employer is treating 50-year-olds better than 61-year-olds, and that's discriminatory. But the court didn't agree. The court said that Kentucky's retirement system was not motivated by age discrimination, but instead by a desire to allow those disabled in the job to receive retirement compensation. This particular worker, because he was already 61, didn't need any help to get to retirement. He was already at a point that he could enjoy that benefit as a retired and also disabled individual. The purpose of the disability rules is to treat a disabled worker as though he had become disabled after rather than before he had become eligible for normal retirement benefits. So the logic didn't apply to this particular plaintiff because he was already eligible for normal retirement benefits, so he did not need the assistance. You don't need to know the name of his case. I don't want you to dwell too much on it. It's a little bit more complicated than it's really useful for us to get into. But this is just one of these examples where the rules about retirement benefits are, the courts look at those and recognize that there's a lot going on in this area. And so discrimination is not always assumed as it might be in a demotion case or a termination case. Here's another one of those opportunities to hear the announcement of the decision if you find this one interesting. So let's go on and talk a little bit more about the Older Workers Benefit Protection Act. We kind of given you a little bit of a high point, but let's drill in a little bit more. As I said before, it only applies to ADEA claims. It doesn't apply to ERISA claims. Of course, ERISA stands for Employee Retirement Income Security Act. And it doesn't apply to any of the Title VII claims, sex, religion, race, color. Doesn't apply to Americans with Disabilities Act claims like disability. It also doesn't refer to non-statutory claims like a contract claim or a tort claim. It really just is about ADEA claim. So you can imagine a situation, you might have a woman who is 55 who is Hispanic, who might file a claim alleging age discrimination, gender discrimination, and national origin discrimination. Okay, so let's say that she's presented with a waiver. The waiver doesn't comply with the requirements of the Older Workers Benefit Protection Act. She signs that particular document. Well, most likely she has waived her gender discrimination claim and her national origin discrimination claim. Her age discrimination claim is going to be okay. She hasn't waived that because the document that she was presented failed to meet these requirements. But you can see what this law says is only going to help our particular plaintiff on the age claim, not on any of the other claims that she might be able to advance. So what is a waiver? A waiver is the intentional relinquishment of a known right. So this is what the plaintiff is doing. He or she is saying, I want to give up this right. And of course, what is typically happening is he or she is getting something else. Oftentimes it's money. It could be reinstatement or something else. And so that's what the Older Workers Benefit Protection Act is really focused on, making sure that these waivers really are intentional and that they really are about a known right. So what is a good description of the Older Workers Benefit Protection Act? It's a statute that establishes the legality and enforceability of early retirement incentive programs and waivers of rights under ADEA. So this is an amendment to ADEA that talks about the kind of documents that are often signed. Now you may think to yourself, why don't we have something like this for Title VII? Honestly, I don't know. It certainly would make sense under Title VII. I suppose an argument could be advanced that older individuals sometimes may be more trusting, or at least that's a stereotype people have, may be less sophisticated. Again, another stereotype that is kind of against the whole idea of eliminating age discrimination, to be honest with you. I'm not sure, though, honestly, why it was limited to ADEA versus expanding to Title VII. It certainly would make sense to expand to Title VII, but that's not the environment we're in. That's not what has happened with the law. And so this course is about what the law is, not necessarily about what the law could be or will be or should be. Many times these early retirement plans are called exit incentive programs. And you can see the word exit here is kind of a synonym for retirement. In many of these cases, especially when you're talking early retirement, these individuals who are quote unquote retiring may not really be quote unquote retiring. I mean, they may be going on to another career or to another employer. They are leaving the employment of their current employer, but it doesn't necessarily mean that they're done working. Again, they may be retiring at 55. Well, most people probably can't afford to stop working entirely at 55. So even though they are participating in early retirement program, probably a better name for it might be exit incentive program. So what does the Older Workers Benefit Protection Act requires? Well, it requires that the waiver be in writing. Well, no big surprise there. That's what we would expect to see. And that it be an understandable form. It can't be in a bunch of legalese. You want something that the average employee can understand. Now, this is going to turn in part on a little bit who that employee is. If the person signing the RIF is the current CEO of a multi-million-dollar company, that person's probably pretty sophisticated. So what the understandable form notion might be quite a bit step higher. On the other hand, you might have a waiver that is being designed to release claims of employees who only have a high school diploma or perhaps don't even have a high school diploma, for individuals whose first language may not be English. Under those circumstances, you can see how what an understandable form might be several steps below that. In my experience, this is an area where companies have not been as successful as they ought to be. It's difficult to persuade attorneys to write something that truly is approachable to the average person. And so it is an area that you have to be careful about. You really do need to make sure it's presented in a way that the workers can truly understand it. Another thing is that it has to provide the employee with at least 21 days to consider the agreement. Now, this is the period of time if this is a one-off situation or just a few people that you are giving this opportunity to. If it's a large group, you have to provide 45 days for everyone in the group. So 21 or 45. And then whether it's 21 or 45, you have to give them at least 7 days to change their minds after signing it. So let's just go through a couple scenarios. So I'm offered the package. I'm offered 21 days. I sign on the 3rd day. I know I want it. I sign it. So then my 7-day clock starts ticking at that time. So from the day I sign it, I get 7 days. It's not 7 days on top of the 21 days. I don't get to 28 days. The only way I get there is if I wait to the final day to sign. Same thing with the 45 days. Let's say my end of employment is due to a large RIF. I'm given 45 days. I sign on the 10th day. I still get my 7 days, but my 7 days start on the day that I sign. Here we go. Let's go through a scenario, see how this plays out. So Mary is 55 years old, so she's covered by the ADEA and also by the Older Workers Benefit Protection Act. She's been employed for 17 years as part of a large reorganization. So we're in the world of 45 days. She was offered an early retirement and asked to sign a waiver of her rights to file a claim under ADEA. But look, she's only given 21 days. For some reason, here we go. She's only given 21 days. She should be given 45 days. She was out of work due to illness for 17 days. I'm not sure that's relevant. I'd want to look at some case law to see if her deadline can be extended because of the illness. Anyway, she signs the waiver when she reports to work after being reminded she only has 4 days left. So she signs it on the 17th day. But she should have, again, been given 45 days, so she should have had a lot more time. Only 17 days had been taken, so she should have had 28 days, so there shouldn't have been any particular rush. She signed the waiver when she reported. 4 days later, Mary changed her mind. Well, she's still in her 7-day window and decides to file a claim of age discrimination. Mary can file the claim for age discrimination because the waiver did not comply with the requirement specifying that each employee be given 45 days to review the waiver, so the 45 days problem. And she revoked within the window for revocation. She should have had 7 days, not 4 days. Either one of those problems would render Mary's agreement unenforceable as written. So you don't need to have both problems. You can just have one before it to be compliable or unenforceable, I guess is what I meant to say. So what happens if we have an enforceable waiver under the Older Workers Benefit Protection Act, but that same self-employee goes down to the EOC and files a charge, and the EOC looks in and goes, wow, this looks like it's got some teeth to it. Well, of course, the EOC didn't sign any waiver, so the EOC is a stranger to the waiver legally, and as a result, the EOC can sue the employer. Even though there was a completely compliant Older Workers Benefit Protection Act waiver, all the I's were dotted, all the T's were crossed. The EOC can still move forward, which is a bummer for the employer because the employer really doesn't want the EOC to do this. But it does mean that whatever the EOC can recover, it's not going to be stuff that the employee gets. The employee is kind of locked out of any remedies, any financial remedies. So the EOC is not going to be able to get a lot. It's likely to be more injunctive relief. We'll talk about what those can look like, but there's probably not going to be any direct financial payoff, other than the fact that the EOC could get its attorney's fees. But since the employee isn't going to be able to get anything, the EOC really isn't in a position to collect a lot of money. And so that would be a pretty good argument for the EOC perhaps not to pursue this in litigation. But the EOC does not always follow that logic. So if the employee signs a defective waiver, when I say defective, I mean it's not Older Workers Benefit Protection Act compliant, the employee is not required to give back any benefits received under the waiver as a precondition of filing suit. This was really controversial for a while. We didn't know what was going to happen. So there's a waiver that's wrong. Maybe it's a waiver like this one, where it should have been 45 days and it was actually 21, or it should have been 7-day revocation period and actually a shorter revocation period was provided, or perhaps it wasn't understandable. It was written in legalese. But whatever the problem was, there was a problem. And the employee signed anyway, and the employee got some money out of this. Now the employee's decided to sue. Well, the question was, did the employee have to give back the money? I mean, after all, there really was no effective waiver. Well, the employee does not have to give back the money. There's a couple of reasons for that. One is a policy reason that that if you make the employee give back the money, essentially the waiver is going to work because most employees aren't going to have the money to give back, and they're not going to be kind of willing to risk the money that they've already gotten. And so the whole purpose of the Older Workers Benefit Protection Act is frustrated because you have this defective waiver that essentially becomes an effective waiver because the employee isn't going to be able to give back the money. The second reason why the waiver still, or the waiver shouldn't be paid back is that it's very likely that the waiver is completely effective for all of the claims other than the age claim. And most of the time people do have other claims. Keep in mind it could be sex discrimination, sexual harassment, retaliation under Title VII, race discrimination, color discrimination, religious discrimination, disability discrimination, some kind of contract law claim, some type of tort claim. I mean, usually there's something else other than age, or that at least people were entertaining the idea of suing under another theory. So it can still have valuable consideration even if another claim is being waived. And so the payment, the worker does not have to pay back any money in order to proceed with the lawsuit. And this is the case. The Cosmair case is the one that says that. Does a release under the older, oh, actually this is the one about this top one. Sorry about this. It's about this portion. The Cosmair is about this one. And the answer is no. A release under the Older Workers Benefit Protection Act does not bind the EOC. The EOC can still go ahead and sue. The EOC may pursue its own claims in response to the filing of the charge and is not bound by the waiver. Again, you don't need to know the name of this case. Okay, so let's talk about harassment and retaliation. Okay, both private and public sector employees enjoy protection from retaliation under ADEA just like they do under Title VII. So what do you have to do to prove a hostile work environment harassment type claim? Well, first of all, you have to show that the I'm sorry, the employee, not the employer, the employee is 40 years or older. In other words, they have to fit into the protected class in order to be eligible to make a claim of harassment. Now, obviously, for the retaliation, you don't have to prove this. You can be retaliated against under ADEA even if you're under 40. The harassment has to be unwelcome. I mean, that seems pretty obvious. I don't think you have really age discrimination harassment that would be welcome. And again, the harassment has to be based upon age. It can't be based upon some other characteristic. And that, again, a little bit of teasing here and there is certainly not nice or appropriate, but the bar is fairly high on this stuff. And so it really does have to unreasonably interfere with the job performance. So simply calling somebody grandpa once or twice, or joking about the person, having one foot in the grave or something like that, even if it really ticks off the worker, it's just not going to meet this standard. It's got to be pretty significant stuff. Now, having said that, if you're the HR professional, obviously you don't want this to happen. Your goal with harassment claims is not to say, well, you know what happened there just doesn't meet the legal standards, so go ahead and do it. I mean, harassment is almost never good for the business, even if it's perfectly lawful, because people are, number one, wasting time, and number two, somebody is getting upset. And if somebody's upset, they're not being productive. And so even though probably a lot of the stuff that might seem like it's age harassment is not going to meet the legal threshold, as an HR professional, you don't want it to happen at all. And so you want to go in there and say, wait a second, stop the grandpa comments, stop the old geezer comments. Just don't do that. Don't do that, because it's not a good business practice. And you may well need to discipline people as a result of that. Of course, you also need to have a basis for ascribing employer liability. And so you want to think through the Farragher-Ellerth aspects of this, just like we had with sexual harassment and all the other types of harassment. You're going to want to provide training. You're going to want to have a complaint process. You want to do prompt and thorough investigations that are designed to resolve these issues. Same concerns you have with age harassment as you will with all the other categories of harassment. Let's consider a story. So Bob is 63 and he's a manager at this company. His supervisor, Mary, frequently makes age-related comments about Bob to other workers. Obviously, that's embarrassing for Bob. Mary encourages the coworkers to be uncooperative with Bob and not to talk to him, as he believes that older people gossip more and reduce productivity. Very strange. Anyway, Bob files a complaint under ADEA against Mary, and yes, very possibly, if it really was this severe, Bob can make a prima facie case for hostile environment under ADEA as age harassment. As we said before, ADEA prohibits retaliation. So let's consider this scenario. Mary's 57 and has been a store manager for 10 years. The employer was trying to establish a more youthful image. So Mary gets demoted, so she isn't customer facing anymore. She's back in an office somewhere. Mary files a complaint with the EEOC. So now this is the discrimination complaint. After she files the complaint, she gets fired. So this is going to be the retaliation complaint. I'm going to tell you a little secret here. Retaliation complaints are usually more legally risky than the underlying discrimination claim. Oftentimes, employers are able to successfully defend the employment action they took that is being called discrimination. Now, we don't know in this case whether the employer is going to be able to do this. Certainly, it doesn't sound like the employer is going to be able to. It sounds like it's age discrimination, because we're not allowed to consider employee preferences, customer preferences in this area. But let's assume for a second that Mary just wasn't that good at her job. And so the fact that the employer was seeking a more youthful image is just a coincidence. The real reason it demoted Mary was that Mary was not very good at being a store manager. So it could be that Mary's age discrimination claim is not actionable if her demotion is based upon poor job performance. The fact that the discrimination claim isn't a good one does not mean that the retaliation claim isn't good. I mean, both can be good or neither can be good, but it could easily be that one is good and the other is bad. Now, it could be that the discrimination claim is good and the retaliation claim is bad, but more likely it's that the discrimination claim is legally insufficient, whereas the retaliation claim is. Now, of course, simply because Mary files a claim and then she's fired does not necessarily approve retaliation. The reality is that retaliation happens. It's also true, though, that sometimes workers file a charge in the hopes of getting a little bit of job security because they file the charge realizing, hey, I'm about to be fired because I'm not very good at my job. And now when they fire me, it'll look like it's retaliation because I just filed my charge. Or then the employee might think, well, they're going to be too scared to fire me because they'll be worried that this will create a retaliation claim. So you need to have more than simply complaint and termination. The closer these are in time to each other, of course, makes the retaliation claim stronger. Punitive damages. What are punitive damages? It's an award designed to punish. You can see at the beginning of the word punitive damage is the word punish. So the goal is to punish the party, the defendant, being sued, rather than to compensate the injured party. In our system, we allow the injured party to keep the money, the plaintiff in this case, even though it's really a windfall for the plaintiff because it really doesn't reflect his or her damages. Punitive damages are available for retaliation claims under ADEA, but they're not available for routine discrimination claims under ADEA. And we'll talk about why that is in a couple of minutes. I'm not going to spend some time on this complaint because it really just applies to federal employees, but federal employees can sue for retaliation under ADEA. So if you happen to be working for the government, then that is relevant to your circumstances. You happen to be HR manager in the government. Okay, so let's talk about remedies. Again, when you see remedies, think damages. What the successful plaintiff is likely to get if he or she wins the case, or may be able to get. So let's look. So what are the things you can get? Well, you can get a jury trial. So you can have the merits of your case heard not just by the judge, but by 12 citizens, and they will also determine damages. So one thing you can get is reinstatement. Now, it's reinstatement is whether you either get front pay or reinstatement. You don't get both. So this is either or situation. You can get affirmative injunctions. This is what the EEOC might be going with a Older Workers Benefit Protection Act deficient waiver. Because the EEOC can't get reinstatement for the worker because that would benefit the worker actually, I'm sorry, let me go back. I misspoke. We were talking about what can the EEOC do when it is deciding to sue when the employee signed a good Older Workers Benefit Protection Act waiver, not a deficient one. So I apologize, I misspoke there. So under those circumstances, the EEOC can't get anything specific for the employee's benefit. So reinstatement's out, back pay's out, front pay's out, double damages will be out. The EEOC may be able to collect attorney's fees. But the one that probably is most interesting to the EEOC is affirmative injunctions. Then this is an equitable remedy that's available to the EEOC. And what the EEOC would be requesting here is some type of requirement that the employer stop some kind of practice or policy or procedure, or that it retrain its workers in a particular area. Obviously, this does not directly benefit the employee, and usually when the employee is suing the employer without the involvement of the EEOC, the employee doesn't really care about this. I mean, after all, the employee is focusing on his or her financial well-being and doesn't really care about what's happening at the employer after the employee has left. The employer doesn't really like these affirmative injunctions either because they can be fairly expensive to implement, but more than that, they're disruptive and they're kind of embarrassing for the company. And so for those reasons, the employers don't like them either, but the EEOC does like them. So let's look at what The individual successful plaintiff can get reinstatement or front pay. The employee can kind of specify which one he prefers. Keep in mind that front pay isn't going to be forever and ever and ever. And so if you have a worker who was subject maybe to a reduction in force and doesn't have too many hard feelings from the employer, they might be able to return to work, get reinstated, and perhaps work for many more years. So the reinstatement might ultimately be more financially rewarding than the front pay. On the other hand, in many cases where there's been a termination, the employee and the employer are really, really angry at each other. And it may well be that the employee wasn't really planning on working that many more years, or perhaps so the front pay option may be the better choice for that employee. The employee can request one over the other, and the employer can also present to the jury what it thinks is the better course of action. Back pay is, of course, the amount of pay that the employee has lost up until the day of the trial as a result of the adverse employment action. Attorney's fees, obviously the costs that the employee is bearing in terms of the fees. And then we have something called double or liquidated damages. We're going to talk more about that in a second. This is the equivalent of punitive damages under ADEA. We don't have punitive damages, but we have something that kind of functions like punitive damages. Again, remember that Title VII, we have some punitive damages, although there's a cap on them, but there is some availability of those types of remedies. Under ADEA, since it's a different statute, we don't have something called punitive damages, but we have something that is probably less than good than punitive damages, but better than nothing. And I think that reflects the fact that initially Title VII did not have any punitive damages, but Title VII was amended in the 1990s and punitive damages were added. You might think, well, at that time, perhaps the Congress should have amended ADEA as well. I don't know why they didn't, but they perhaps didn't because ADEA, since it had been written after Title VII, had already provided something kind of like punitive damages. So ADEA has a different equation, and we'll talk about that in more detail in a second. ADEA does not provide for recovery for pain and suffering or punitive damages beyond the liquidated damages thing. So you may recall under Title VII, an employee can get compensatory damages, the mental anguishy type damages, as well as punitive damages. But the amount of those are capped depending upon the number of employees that the employer has. And the highest number they can be in combination is only $300,000, so it's not a huge amount. Okay, so let's consider the TWA versus Thurston case. Again, this is a Supreme Court case. It held, in order to be able to collect these liquidated damages, there has to be a willful violation of ADEA. And so how do we know when there's a willful violation? What does the plaintiff have to show? Well, a willful violation is one in which the employer knew or showed reckless disregard for the matter of whether its conduct was prohibited by ADEA. So that's the standard, knew that it was a violation or showed reckless disregard. And if that is satisfied, then so the employee is obviously successful in the underlying claim, the employee gets twice the amount of recovery that he or she ordinarily would have. So one of the things that you'll get is you'll get a jury question on willfulness in many ADEA cases. So what's better? Is the Title VII liquidated damages, Title VII pain and suffering compensatory damages or punitive damages better, or is the liquidated damages under ADEA better? Well, it really depends upon what the total number of damages are and how much that plaintiff lost in terms of pay. And it usually turns ultimately on what was this person's underlying compensation and have they been completely out of work. Imagine that you have that your client, let's say you're an attorney and you're representing the plaintiff. Your plaintiff was earning $200,000 a year prior to his or her reduction in force, and he or she has been out of work for 2 years without any income. Well, they have lost $400,000. So if you double that, you can see you're doubling $400,000. That is more than the maximum you can get for compensatories and punies under Title VII. So it is possible for ADEA to be a greater punitive damage recovery than you have under Title VII. But probably more commonly, Title VII, especially for large employers, does provide a higher likely amount for those additional things. This level of proof is necessary in order to get liquidated damages, which are double damages. That's what that willfulness test is all about. So what are liquidated damages? These are a predetermined amount of damages. We'll see these oftentimes in contracts, but here it's predetermined by the statute. So under the ADEA, it is the unpaid wage liability if the act is willful. In other words, the claimant would receive twice the unpaid wage liability if willfulness is proven. Okay, let's talk about equitable relief. I've kind of mentioned that a few times. This is, again, relief that isn't money. It's things like injunctions. It can also include reinstatement and promotion. It's things other than, let me just write you a check. A reinstatement, a form of equitable relief, can occur instead of front pay. Front pay is, let me write you a check. That's not going to be considered injunctive relief. Back pay and front pay are not examples of equitable relief. We call those types of relief legal relief. So we've gone through all of our topics except for ERISA. Let's talk about ERISA. We've kind of touched on it briefly. ERISA stands for Employee Retirement Income Security Act. It is the primary federal law that regulates private employee benefits plans, including pensions. Generally speaking, under ERISA, employers are not required to provide benefits. That's somewhat, the answer is somewhat different if we're looking at the Affordable Health Care Act, which came many, many years after ERISA. But generally speaking, what ERISA says is if an employer chooses to provide benefits and wants to take advantage of certain tax benefits, the employer has to set up its benefits in this way. But the employer doesn't have to have benefits at all, and the employer could choose to have benefits and just not take advantage of the tax advantages. And that's okay too. But if he wants both, he's going to have to follow the rules of ERISA. ERISA has set up benefits, the requirements that it has for benefit plans generally makes benefit plans more expensive for employers, but keep in mind that ERISA is also giving tax breaks to employers, and so employers do have an incentive to dot the I's and cross the T's as ERISA requires. ERISA does not permit employers to discriminate against certain employees in their determination of eligibility for pension benefits. You can't have an ERISA benefit that, for example, tends to favor highly compensated workers in ways and exclude lower compensated workers. That's called discrimination. It doesn't mean it's kind of wage discrimination. It doesn't mean discrimination like when we're referring to Title VII. I mean, it doesn't have to impact women more than men or African Americans more than Caucasians or anything like that. It's just looking at how much do people earn. You cannot, there are some ways you can favor higher earners over lower earners, and you certainly can do it through non-ERISA plans, but managing through that system is something that requires a very sophisticated understanding of the law. ERISA has reduced the likelihood of employees losing their benefits when their companies undergo management reorganizations. And it also has reduced the likelihood of employees losing their benefits when they become sick and were forced to quit their job prior to the time their pension benefits vest. Also, COBRA is an important benefit in this area. Now, we've talked about that before. That's another benefit. Now, I use the term reduce the likelihood. This is not a magic pill here. Unfortunately, one of the great sources of people having to file bankruptcy is health crises. And that happens even when people do have health insurance through their employers or other benefits through their employers. So we haven't completely cracked this nut as a society, but certainly these are ways of reducing that likelihood. As I said before, ERISA does not require that employers provide any benefits. It just kind of regulates that process when employers choose to and also take advantage of tax benefits. But certainly retirement plans are one mechanism that ERISA does address. So we're done with the topics. We've covered an overview of ADEA, Age Discrimination Employment Act. We've compared it to other statutes such as Title VII. We've talked about the mechanisms the law provides for potential plaintiffs from filing claims of age discrimination. We've talked about the Prima Facie case framework and how it works with ADEA, and we've compared and contrasted it with Title VII. We looked at the similarities and the differences. We discussed the special case of RIFS and how that's a particularly sensitive subject for age discrimination claims. And then we talked generally about the topic of retirement, both mandatory retirement, which is legally a rare beast, and also voluntary incentives, which are generally quite broadly permitted. And then we talked about waivers under the Older Workers Benefit Protection Act. We talked about what happens when a waiver is bad, and what happens when an employee signs a good waiver and the EEOC gets involved. And we talked about what makes a waiver good or what makes a waiver bad in very brief terms. There's a lot more details to that, but we didn't want to do a deep dive on that. That's something for you to explore and look into as you happen to be confronting one of those issues in your professional life. We talked about age harassment and also a retaliation claims under ADEA. We talked about the remedies that are available to successful plaintiffs under ADEA, and we discussed ERISA, especially as it relates to retirement benefits. So here's some takeaways as you things that you want to think about as you consider how to manage your workforce, considering the requirements of ADEA. Obviously, you want to evaluate the true requirements for a position. You don't want to put physical requirements on a position that might exclude older workers who otherwise could do a good job. And you want to be sure that your job descriptions reflect those true requirements. You want to test for those characteristics, not for other characteristics. It may be easy to give an eyesight test and difficult to do a test in which you're actually measuring a person's ability to do the job. But an eyesight test could unfairly and illegally exclude workers who could otherwise do the job. You want to pay particular attention to RIFs. I mean, not just with respect to age discrimination situations, but honestly, age discrimination is a special risk with RIF situations. Many times employers choose to use previous employment appraisals, maybe the annual appraisal, to sort through that. Unfortunately, in many cases, because they were not prepared to be bulletproof, they may include a fair amount of subjective material. And so if you work in HR, you want to make sure that the annual appraisals are solid, are as objective as can be, don't have any hidden biases in them, and because you never know when it's going to be used for a reduction in force. And you want, of course, all appraisals to be objective, detailed, and carefully documented. Ideally, you're not going to have any job requirement that has an age component unless you happen to be in one of those few safety-sensitive type areas. But if you have to have one, be sure that you look at it very, very closely to make sure it complies with the law. As always, but when termination decisions are being made, whether it's part of a reduction in force or otherwise, you want to make sure that things are being done fairly and in compliance with the law. If you have an older worker who's being effective, you want to be very careful to make sure that the age was not part of the reason why this action was being taken. And you want to make sure that any kind of recruiting literature has been scrubbed to make sure there's no kind of subtle age comments being made. It's a good practice, for example, if you happen to have these types of brochures prepared, maybe as recruiting things, that you have a range of ages, also a range of genders and a range of ethnicities, and even perhaps having different able-bodied and less able-bodied candidates in the photos. Employers should take age-based remarks, comments, jokes seriously. They're disruptive of the work environment and they may well be unlawful. And I think we're done now. So thank you so much for your attention. As always, if you have questions, please reach out to me. My email is cgruver, C-G-R-U-V as in Victor, E-R, @collin.edu. or better yet, stop by and we can go through and talk about these issues in more detail, go through more scenarios, and so you have get at whatever questions you have resolved. I thank you for your attention, and I hope that you have a wonderful day. Thanks for listening.